Bylaws. So bylaws are the governing rules for an organization. They're the internal document that you use to say, how do we do things? How do we hold elections? How many board members do we have? What are their responsibilities? How do we handle conflicts of interest? Although you may have that in a separate policy that we'll talk about. So they're an internal document. You may get requests from the state, the IRS, or your grant makers to see that document or to affirm that you do have bylaws, but for the most part, this is a document that you're going to use internally. So unlike the articles of incorporation that we'll cover or the 501c3 application, you're not going to file them with anywhere. They're not a publicly filed document, although you do want to make sure that they're available to your board members, your membership, if you have a membership, your staff, if you have staff. So you want to make sure that because they're an internal document, that they are easy to use. They're clear, they're easy to understand, so that you can follow them. We sometimes see bylaws documents that are 30 pages or more, and that's really more than you need for a small nonprofit that's volunteer-led that may not have a large budget. Larger organizations may have more complex bylaws, but for the most part, you want to stick with, okay, what do we need to put in this document? That's not, you're not going to be amending this document frequently. You want to amend it as needed. But what do we need to put in this document that reflects the way we operate now? Because you should always be following the bylaws. You don't want them to be an aspirational document. You don't want to say, in 5 years, here's how we want to operate. The bylaws should say, here's how we operate now, so that when there are any questions or disputes, everyone can go back to the bylaws and look at them and say, here's how we've decided to operate. So we have a sample set of bylaws that we can send to your organization as a starting point, or that you can use and make whatever changes are appropriate for how your organization operates and what works for you. And again, you want to amend this document as needed. So I'm going to cover some of the sections that you should include in your bylaws, but keep in mind that this is a flexible document. So really it should reflect where your organization is now and how it operates. Some of the key components that you want to include in your bylaws are, first, name and purposes and principal office. So these sections, and you'll see in our sample bylaws if you have a copy, that we in our sample, the name and purposes are as set forth in the articles of incorporation. So that's what we have in our sample bylaws. And the reason for that is that if you plan to incorporate with the state to create an official nonprofit entity, you are going to file articles of incorporation. And that document is required to have information about the name and purposes of the organization. So if you're going to incorporate, you don't want to have that information in two different documents, the bylaws and the articles of incorporation, because then there's the potential for one document to get changed if your name and purposes ever change in the future, but for the other document to not get changed, to be missed in making that amendment. So you don't want to have two documents that conflict and say different things. So the best practice is to put the name and purposes information in your articles of incorporation, and in your bylaws just refer to the articles of incorporation and say, you can find this official information in this document. Principal office. If your organization has an office, you may want to include that in the bylaws document. If it doesn't, if you change where you meet in members' homes or libraries or other locations, you may not have a principal office, or it may change every few years as your officers change and you change where you store your important documents. So you may just want to say the principal office shall be set by the board of directors, and that way you're not locked into something in the bylaws that you would then need to amend the bylaws to change. You want to include in your bylaws sections on members, directors, and officers. And if you have a membership organization, like a community association, a church, or other religious institution, you have a membership, and it's that membership that has the power to elect directors. So the board of directors are chosen by your membership from among the members. For some organizations, they have once the directors are chosen, the directors then select the officers, who are the leaders of the leaders. Those are the president, the vice president if you have one, the secretary, and the treasurer. So that's how it works for some organizations. For others, the membership elects both the board of directors and the officers. So whatever works for your organization, just make sure that what you have in the bylaws is what you're following. Some groups have asked about, well, what about things like the World Wildlife Federation? So you become a member, quote unquote, and you get a tote bag. You get to, maybe you get a newsletter from that organization, but you want to think about membership. When we talk about membership in a legal sense, what we're talking about is people with the power to make decisions for the organization. So a membership organization like a community association, it's the members who choose the leadership. It's the members who have the power to amend the bylaws. They might have other powers and privileges that are laid out in the bylaws. For other organizations, when they talk about membership, they're not talking about membership in a legal sense, where you have the power to govern and make decisions for the organization. So for those large national organizations where you can become a member, get a card that you carry, get the updates about what the organization does, that kind of membership does not grant you the power to make decisions about the organization and elect the directors. So your bylaws is where you want to make clear, here's who the members are, here's who's eligible for membership. So in your membership section, you'll want to say who may be a member. For a community association, you'll want to lay out, here's what our geographical boundaries are as an organization, and members are those people who live within the community, within those boundaries. Maybe you also allow people who own businesses or representatives of institutions within the boundaries to be members. They may have to pay dues, and you would want to say in the bylaws whether the board of directors will set dues. I don't recommend stating a specific dues amount in the bylaws, because then you would need to amend the bylaws if you ever need to change the dues. So you might just want to say the board will set the membership dues. And then you'll want to say what their rights and responsibilities are as members. Do they have the right to vote? Do they have the right to amend the bylaws? And if they are, if you have a voting membership, if you're a membership organization, then your members should have the power to elect the directors and amend the bylaws. The directors section describes how the leaders of your organization operate, what their responsibilities are, how many there are, how are they elected, what is their term, and how can they be removed if necessary or resign. So it's always a good idea to include a range of directors, the number of directors, and that's what we have in our sample set of bylaws. So you might want to say there shall be a minimum of 5 board members and a maximum of 15. And as long as you're within that range, you are in compliance with the bylaws. So that way, if someone needs to leave the board, and you are looking for the right fit to replace them, then you have some time, because you are still within, if you have a 7-member board, one person leaves, and your bylaws call for between 5 and 15 board members, you've still got, you're still within that range. You'll want to describe how they're elected by the membership, or if you're not a membership organization, by the current board of directors. The term is really something that you can set, but you want to make sure that you do have a term for the board. So when someone is elected to the board, they know that they have been elected for this amount of time. So that might be 2 years, 4 years, 1 year, whatever works for your organization, but make sure that once that term is up, you are holding elections so that you can either re-elect your board members, bring in new members, but constantly be renewing your board so that there are clear moments where new leaders can come in and your board members who have been serving can leave the board. Officers. So officers are the leaders of the leaders, and you want to describe in the bylaws what their specific roles and duties are. So define what specific officer positions you require. And again, Maryland law says you must have a president, a secretary, and a treasurer, and many organizations also choose to have a vice president. So define what the duties of those positions are. And remember that if you include other officer positions in your bylaws, some organizations include historian or sergeant at arms. If you write that into your bylaws, you must have someone in those positions at all times. So you may want to say that you'll allow other positions as created by the board of directors, but as long as you don't include them in the bylaws, you don't need to have them filled at all times if there's not a need for them or if there's not interest in that position. You'll want to include how the officers are elected and what their term is. And keep in mind that because your officers are part of the board of directors, they must have time in their board term to serve as an officer. So for example, if you have a 4-year board term and a 2-year officer term, you still have time. If you've served 2 years of your 4-year board term, you can run for election and then still have 2 years left in your board term to serve out that 2-year officer term. And then you'll also want to include a removal and resignation section for your officers. Meetings. So Maryland law requires that you have at least an annual meeting, but most organizations are going to meet more often than that. So whatever you include in the bylaws, again, is what you want to do. If you call for monthly meetings in your bylaws, make sure you are meeting monthly. If you're meeting monthly but you maybe skip a month in the summer or around the holidays, you might want to say the organization shall meet on a quarterly basis. And that way, as long as you're meeting on a quarterly basis, you can satisfy your bylaws, follow your bylaws, but still have room to meet more often as necessary. You'll want to include a provision for what the required notice is for meetings. So for the people entitled to attend the meeting and vote at the meeting, what notice requirements are there? And quorum. So quorum is the number of people that need to be present at a meeting in order for a vote to take place. And this is going to be different for your board and your membership. For a board meeting, you may want to set the quorum at something like half of the board members. So 50% of your board members need to be present in order for a vote to take place. So if you have a 7-member board, then you would need 4 out of those 7 members to be present in order to take a vote. And then you would also have a provision in your bylaws stating what the required vote must be. So for many organizations, this is vote by majority. So out of those 4 board members who are present, in order for the organization to have a quorum at that meeting, you would need 3, a majority of those 4, to make a decision. So that way you've set the process for how many people need to be at a meeting so that you are able to have at least a certain level of discussion and input from the board, and you've said how that vote must take place. So that's for a board meeting. For a membership meeting where you've got a much larger group of people who don't have the fiduciary duties to the organization, they might not be as involved, you don't want to set the quorum quite as high as for a board meeting. So for a membership meeting, you might want to set the quorum at 15% or 20% or 10%, whatever works for your organization and whatever you think is an appropriate number of people to make decisions. You want to think about what is realistically the number of people we're going to be able to turn out for a meeting. So for a community association that has 100 members, you might set the quorum at 20% or 15% and say, as long as we get 15 or 20 members at the meeting, then a vote can take place. If you can't turn out that many people, then you want to set the quorum lower so that you can actually make decisions at your membership meetings. The committees section in our sample, you'll see it doesn't include any actual descriptions of committees. What it focuses on is saying if any committees are created by the board can't give away any of its final decision-making power because the board has those fiduciary duties that committees might not. You might not have every board member on a committee. You might have non-board members on a committee. So you always want to make sure that the final decision is left to the board of directors as a whole. The committee might investigate something, give its research to the board, and make a recommendation, but it's the board that should make a final decision. And you might not want to include any committees specifically written into the bylaws unless you're sure you're going to have those committees operating and have people on them that are active at all times. Because again, you need to be following your bylaws. So if your bylaws state that you will have an event committee and an elections committee and all kinds of other committees, once they're written into the bylaws, you have to have those committees. So you may want to just leave it open-ended and say the board may create committees as it deems necessary. You should also include a staff section in your bylaws if you do have a staff. So you probably won't need that until you have a staff operating, but you'll want to describe how are staff members hired, how are they overseen and managed by the board. You'll want to include a conflict of interest section describing how the organization will handle conflicts of interest. And what we recommend is including in the bylaws a provision stating that conflicts of interest will be handled according to a separate conflict of interest policy that I'll cover next. Indemnification. So indemnification means that if there is liability that comes up, a lawsuit, something happens as a result of an organization activity or decision, indemnification means that the organization will step in and protect, will indemnify the people involved in the organization from liability. So for example, if the organization has an event and someone is injured at the event and they sue the organization itself, the board members and other people involved in planning the event, indemnification means that the organization will defend that lawsuit so that the individuals on the board and other volunteers are not on the hook for that liability, that injury that happened to that person. So this is a really big benefit that comes with, once you've got it in your bylaws, you want to incorporate. So this liability protection through indemnification really comes in once the organization incorporates, which we're going to cover. So keep in mind that you want to include this indemnification provision because all of the people who volunteer with and work for your organization are doing this because they believe in the organization's work. They are hopefully they are operating in the organization's best interest. They're acting appropriately using their good judgment, and so you want to protect them from liability so that they are able to do this work in the best way that they know how. Indemnification allows people to do this work, this charitable work, and be protected from liability as long as they are acting appropriately in the organization's best interest and not maliciously or negligently. You'll want to include a section on compensation stating that your board members serve without compensation, they're volunteers, but they may be reimbursed for reasonable expenses for things they buy on behalf of the organization. You'll want to include a provision on fiscal year stating what the organization's fiscal year is. Many organizations choose to be on a calendar year, so January 1st to December 31st, but you may want to be on a different fiscal year if you have a major grant maker who's on a different cycle. You'll want to include a provision for action without meeting if you do allow the organization to take action without having a meeting. So for example, if you have something that comes up and you need to make a decision before the next scheduled meeting, under state law, any decision that you would otherwise have to take a vote on can only be made, if there's not a meeting, can only be made if everyone agrees in writing with that decision. So if you are trying to get the board to make a decision, there's short notice, you really need everyone to make a decision quickly, everyone would need to respond and say, yes, I'm in favor of that decision in writing. So you might want to get everyone to sign off by email on that decision, but again, it would need to be every member of usually it's the board making this decision. So if one person says no or doesn't respond, then you couldn't use this provision legally under state law. You would need to make that decision in a meeting with quorum the way you would with any other decision. You'll want to include an amendments section in the bylaws. So say, here's how we'll amend this document if we need to in the future. Really important to include this provision because as you operate and grow, you may find that there are things you have in the bylaws that you want to change so that they work and are able to support your organization better. So make sure you include the amendments section. And then you'll have the secretary sign and date once the document has been approved. Some final thoughts. It's a good idea to have a bylaws committee. So some group of people who can come up with a draft or come up with some things that they think are important to change once you have a document in place, and get buy-in from the board. So say, what do you want to see? Then they can take that back and work on a draft. Community Law Center can help with reviewing the bylaws, and I think it's worth it to talk with an attorney to make sure that the way that you're drafting the document is going to be what's most supportive for the organization, that you don't include something that contradicts state law, or that you have a set of eyes reviewing it that can give you that legal opinion. When you have a draft that you're ready to bring to the board or the membership, make sure you are providing advance notice and copies for people to review so they can bring their questions, and then vote on them. If you're a board organization, it's the board that will decide whether to approve or amend the bylaws. If you're a membership organization, it's the membership that will decide whether to approve or amend. So take a vote. Once they've been approved, sign and date them, and then use them. This is the document that, you don't want to look at it as just another thing you have to tick off to get through the process of starting a nonprofit. You want to think about them as a tool for your organization to use to operate most effectively so that everyone is on the same page. Conflict of interest policy. So in your bylaws, you're going to reference that you have a policy, and some organizations include their policy in the bylaws. What we recommend is having a separate conflict of interest policy so that you can address situations that might arise when someone has an interest in their lives and their decision making that could conflict with making decisions in the best interests of the organization. So a conflict of interest could occur when a director who is part of the organization, they serve on the board, also has another interest in their lives that could conflict with them making the best decision for the organization. So the example I always use is you're on the board of a nonprofit, and the nonprofit is holding an event and it wants to make t-shirts for the event. You say, I own a t-shirt making business. I can provide the t-shirts for the event. Or maybe a family member of yours has a t-shirt making business. So right there, you've got a potential conflict of interest because in your role as a director, you always have to be making decisions in the best interest of the organization. What's the best business to choose to make the t-shirts for our event? But you also have your own interest, your business or your family member's business, where you are trying to get the best deals for your business, increase awareness of your business in the community. So you've got those two interests in conflict, your board role and your personal business. Having a conflict of interest policy in place means that board members are acting in the best interests of the organization and not in some other interest. So the policy describes how the organization will avoid these conflicts of interest and how it will address them if they do come up. There's 4 steps that you want to use when a conflict of interest does arise. So in our example where a board member owns a t-shirt making business, the first step is the director will go to the rest of the board and say, I have a business, I make t-shirts, and I could make t-shirts for the event. But it is a potential conflict of interest because it's my business and I stand to benefit from getting this contract to make the t-shirts. Then the second step, the board will determine whether that going with your business is in the organization's best interest without input from you. So they may have questions for you that you should answer to the best of your ability, but once you've disclosed the conflict and answered those questions, you should step out of the room and allow the board to have a discussion about what's in the organization's best interest without you there. Then the third step, still without you in the room, the board will take a vote on whether to go with your business to make the t-shirts. And in this stage, they may decide, well, we could get a better price from this other business, or, we've worked with another business before. So they might say, no, we don't think it's in the organization's best interest to go with this board member's business. On the other hand, they might say, we do want to go with this board member's business because maybe they're offering the best price, or they're right in the community, or they do good work and we want to have a relationship with them. One thing that boards should consider is that even if it might be in the organization's best interest, even if it's a good price or whatever other factors they're taking into consideration, they might want to avoid even the perception of a conflict of interest, because if people in the community perceive that the organization is benefiting its board members in some way, that might harm the organization's reputation. So that's something to consider. So whichever decision the board makes, it should take a vote to make that decision, and then step 4, document everything in the meeting minutes. And that way the organization knows, we had this situation that we identified as a conflict when it arose, and here's how we handled it. And if anyone has questions about that, then you can explain, here's what our policy is, and here is how we manage these conflicts. So the best practice is to have a conflict of interest policy, and we do have a sample document, conflict of interest policy, that organizations can get a copy of if they contact Community Law Center. So you can use that document to create your own conflict of interest policy. And when these situations do arise, then you can say, okay, here's the policy that we had in place, and ideally you've got every board member reading that policy and signing it when they join the board, and every year just renewing their commitment to, here's how we handle conflicts of interest. You might also want to have a conflict disclosure form, so when someone joins the board, you can say, here's this document, please fill this out to list if you own a business, if you are affiliated with other businesses or institutions or organizations that might potentially have conflicts with this organization.